an announcement here.
That's the other document.
This is one of those courtroom hearings where the numbers alone should stop you in your tracks. A defendant already out on a $250,000 bond for aggravated assault, now back in court after allegedly committing an even more violent crime, armed robbery, just weeks later. Judge Stevens isn't just reviewing paperwork here. He's weighing public safety, accountability, and whether bond conditions mean anything at all when someone keeps reoffending. As the details unfold, you'll hear how firearms, tracking devices, and social media evidence collide in a way that makes this case impossible to ignore. The question looming over this courtroom is simple. How many chances is too many?
Is 500 up? Are you Christopher Harris? Okay. Who's posting your bonds? Who posted your bond? You had a bond when you were arrested for $250,000? Who did? No, who paid it? You? That's $25,000. I guess did she win the lottery or something?
My mom was size.
It's 5, so she posted 50,000. Okay. There's a motion to increase the bond. Well, see, here's the deal. You're arrested, so she lost that bond. Whatever she paid, she's out that money, $50,000. Okay, that doesn't bother you at all?
This exchange reveals something many people misunderstand about bail. When the judge talks about the $250,000 bond, he's not talking about pocket change. That typically means 10 to 20% paid up front, which in this case appears to be $50,000 posted by the defendant's mother. And here's the critical part. Once the defendant is rearrested while out on bond, that money is at serious risk of being forfeited. The judge's reaction isn't about shaming. It's about responsibility. Bond isn't a reward. It's a financial promise to the court that the defendant will follow the rules. So let me ask you, if someone knows their own family's money is on the line, should that weigh heavier in a judge's decision to grant leniency?
And there was a bond set of, it looks like $250,000 was the bond on July 24th when you were arrested for this indictment. Then afterwards, about a month later in August, a couple of weeks ago, it is alleged you committed aggravated robbery and your bond was set at $500,000. So he's got a $250,000 bond and now a new $500,000 bond. Is that right?
That's correct.
Okay. And August 25th. Have you seen this probable cause affidavit?
I just got it today. Yes, I just got it today, Judge. With the motion to increase the bond.
Who set the bond on this one? Does it, I guess, a magistrate?
The 500 or the 50?
The new one, the 500,000.
The 500 was set by Judge Cerrone.
Okay. So on this first bond, the indictment for aggravated assault, the court has reviewed the probable cause affidavit, which states that on July 19th, Beaumont police responded to East X Freeway in reference to a victim of a shooting, and the victim was suffering from multiple gunshot wounds to his lower extremities of his body. And Uh, the defendant in this case, Christopher Harris, it's alleged the defendant entered an unlocked apartment, produced a handgun, fired 6 shots at Albritton, causing serious bodily injury, and then fled the scene. So, shot somebody several times and then fled. And so a $250,000 bond was set in that case. So, just a few weeks later, and it looks like we're talking about 5 weeks later, on August 25th, 2025, after the defendant had posted a $250,000 bond, police responded in Beaumont to an aggravated robbery and spoke to the victim, who stated he was robbed at gunpoint by 3 black males who stole his belongings as well as his Lincoln Navigator vehicle. And police located quickly the stolen vehicle at Cardinal Oaks Apartments here in Beaumont with the lights on and the engine running. And observed someone named Arthur Gouldsby standing in the driver doorway with the driver's door open. He was transported to the station, confessed to his involvement in the robbery, and stated that he, along with Harris and Brandon Johnson, the defendant Harris and Brandon Johnson, who were armed with handguns, lured Wilson to pick them up under the premise of going to a party. Once they directed him to a secluded area, Johnson asked Wilson if he could drive the vehicle. Wilson pulled over, at which time Johnson and Harris pulled guns on Wilson, stole his silver necklace, watch, cash, and told him to run. Johnson shot at Wilson as he was running away. Who does that? I mean, you got them. You have 3 people at gunpoint and then steal everything, tell them to run, and then shoot at them. Yeah, it was. Johnson shot at Wilson as he was running away. They all fled in the victim's stolen vehicle.
This is where the case goes from troubling to outright alarming. The defendant is on an ankle monitor, meaning law enforcement can track his movements. Yet he's allegedly present at the exact location of an armed robbery. Not only that, but investigators find Instagram video evidence showing him wearing the victim's stolen jewelry. From a legal standpoint, this is devastating. Electronic monitoring is meant to deter crime, and social media often becomes the final nail in the coffin. The judge's repeated, "Who does that?" isn't rhetorical. It reflects disbelief at how brazen this behavior appears. So here's the question for you. When technology makes violations this obvious, should courts still believe supervision alone can protect the community?
An Instagram account belonging to the defendant has a video of the defendant wearing the jewelry of the man's jewelry who was stolen from the robbery. Okay, there is a motion to increase the bond. Anybody else want to be heard? I've read it, the 4 corners.
Nothing from the state, Your Honor. I believe it's.
What's the defense say on this one? Give it your best shot.
Judge, I think at least from what your clerk said, my client has not made a $500,000 bond at all. And the $500,000 bond is the one that you just said was set by the ruling. I believe the state said that he did make a $250,000 bond. So in essence, Judge, that bond has already been doubled to the $500,000, which he has not made. So I'm asking the court to keep both cases at the 500,000 because that's already been doubled and that's something that he has not made and it's doubling what he did make. So
Right.
I'm just asked to keep it at that 500,000.
Anything, statements?
Your Honor, we're just asking for the other one is at 500,000. We would just ask for the 900,000 on there because of the nature of the offense after he just committed the very serious aggravated assault, and then gets out and does this aggravated robbery, again shooting at an individual not much later from when the other, I think within a month.
Did you look into it?
You're not talking to him. You talk to your lawyer. You don't discuss things with him. That's not appropriate. But you can talk to your lawyer and then he can ask the questions. Unless you want to release your lawyer, you can be your own lawyer. Is that what you want? No. That would be wise. Anything else? Okay. The court finds as follows. $250,000 bond was set in this first case of aggravated assault, use of a deadly weapon. And not only was $250,000 set, but the defendant was required to have a tracking device. What were the other conditions of bond? Were there any other conditions that it shows? Because I don't have a lot of.
No contact with complaining with witness remain in Jefferson County and to testify.
Okay. So just a few weeks later, I'm sorry, this was on or about July 19th is the indictment date. And he was arrested on or about July 24th for that first robbery that he was indicted for, then posts his bond for $250,000. 1 month later, approximately 4 weeks later, August 25th, here in Jefferson County, Texas, the defendant commits another similar robbery, a aggravated crime using a deadly weapon, where defendant and others robbed the victim, and the court finds that the first court's conditions of bond were pretty serious, and in spite of that, the defendant defied logic that he would be placed at the scene of a crime if he commits a crime because of the monitoring of the ankle. So it's obvious that the conditions of bond that were set, a high bond amount, and ankle monitoring him did not deter him from committing a more violent crime. So he is in custody and there is no bond. The court finds that there are no reasonable conditions that can protect this community from these bizarre, violent crime need, and for the protection of the people and to see that the Constitution works so that we can live in peace. The defendant needs to be sequestered in jail because of his propensity to commit violent crimes with firearms, including robberies, and aggravated assaults. So there is no bond, and his bond is revoked on the $250,000.
In the end, Judge Stevens delivers a ruling rooted firmly in public safety. After reviewing both cases, an aggravated assault involving multiple gunshots and a subsequent aggravated robbery with firearms, The court concludes that no set of bond conditions can reasonably protect the community. The result is decisive. Bond is revoked. The previously posted $250,000 bond is forfeited, and the defendant remains in custody with no bond at all. The judge also highlights a rarely discussed victim, the defendant's own mother, who lost tens of thousands of dollars because of his choices. This case is a stark reminder that bond is a privilege, not a shield from consequences. If you found this case as shocking as we did, make sure to hit that like button, share your thoughts in the comments, and don't forget to subscribe for more jaw-dropping courtroom breakdowns.